Thank you, Madam. Yesterday, I was about to take the court to generics. I think for the sake of brevity, I can say that up and running submission on generics is essentially set out in our skeleton argument, paragraphs 12 to 15. Just for reference, that's in Core Bundle 6, page 75. But given Decker's insistence on its elusive claim that the Court of Justice first established the harmful nature of the agreement in question there, and the relevance of that to the wider argument about the relationship between the test said to emerge from carte bancaire for finding a restriction by object and selective distribution systems, it's useful to look a little closer at generics, which is in volume 3 of the Authorities, tab 22, page 1022. Before we go to the judgment in generics, I think it's important to be clear what the exercise that the court was involved in generics is about. What is the purpose of the carte bancaire test? It's to establish whether the restriction in question reveals a sufficient degree of harm to be classified as a restriction by object, and as carte bancaire emphasizes, the importance is in sticking to that question of object rather than effect, because otherwise there'd be no point in having that distinction. And I should therefore, just before we get to the judgment, draw your Lordship's attention to something in Advocate General Cocott's opinion, which you'll find at page 1025. And there, paragraph 174 of the Advocate General's opinion, the Advocate General reminds us that, as stated in the case law, Article 101, like the other competition rules laid down in the treaty, is designed to protect not uniquely the immediate interests of individual competitors or consumers, but also to protect the structure of the market and thereby competition as such. In order to find that coordination between undertakings has an anti-competitive object, there does not therefore need to be a direct link between that practice and consumer prices. And there's a footnote reference there to several very well-known cases on Article 101, T-Mobile Netherlands, GlaxoSmithKline. So the point being made by the Advocate General is to remind us that sufficient harm to competition is to that wider concept of competition as a goal under the treaty. And that leads me to pick up on what I submit is a basic error of Decker's case yesterday. At several points yesterday, my learned friend Mr. Dimitriou transgressed into the realm of facts rather than addressing the question of restriction by object. Mr. Dimitriou claimed that the clause had no effects, that it had no competition, no effect, no impact on the competition in the market, and that taking the facts at their highest, for up and running, that it came nowhere near an obvious effect on competition. But that, I submit, is not the correct approach. Now, turning to the judgments, we can start at paragraph 67, which is on page 1061, where the court refers to the sufficient degree of harm to competition test. We were taken to that yesterday, so I won't read that again. I just recall what Advocate General Cocott said about the nature of competition that one is protecting here. And then paragraphs 69 and 70 do indeed observe that delay in the entry of generics keeps prices of drugs much higher. Putting the most favourable gloss on it for Decker's, this appears to be an instance of the court identifying something from the context of a patent settlement agreement that might explain a classification of restriction by object, but that's not really articulated there. It just amounts to saying that generics bring down prices, and of course we could say the same about clearance websites with running shoes, especially since we now have it on authority from your lordships that the internet and price considerations are very valid in searching out running shoes.
That's not authority, that's just gossip.
But it doesn't say there that any agreement that can be characterized as delaying generic entry is a by-object restriction. And paragraph 71 makes the seemingly disconnected point that it must be determined if the agreements reveal a sufficient degree of harm to be condemned by object. And that indeed is the last time that the judgment refers to that test. Indeed, it goes on at 76, we're now on page 1062, to emphasize that patent settlement agreements in general can't just be condemned out of hand as restrictions by object. It indicates that market exclusion agreements are by object. It doesn't elaborate on why they cross the threshold of a sufficient degree of harm. And then at paragraphs 81 to 83, over the page on 1063, various expressions are used about possible criticisms of patent settlement agreements. 81, 82, there's some rather faint findings about how they are liable to or may restrict competition. In 83, there's a slightly firmer pronouncement that practical cooperation rather than risk of competition is an infringement by object, referring to the beef industry development case that you were taken to yesterday as well. And again, at paragraphs 84 to 86, the court again recalls that the settlement of patent disputes is not necessarily a by-object restriction. And then it just goes directly to paragraph 87 to explain how this conundrum is to be resolved, saying that such a characterization as a restriction by object must be adopted when it is plain from the analysis of the settlement agreement concern that transfers of value provided for it cannot have any explanation other than the commercial interest of both the holder of the patent and the party allegedly infringing the patent not to engage in competition on the merits. So the objective aims of the agreement are the decisive element, assuming always that not to engage in competition on the merits is indeed something that reveals a sufficient degree of harm. Say instinctively it does.
Can I just ask
they don't
you?
say that. Yeah.
Can I ask you to go back? But first of all, 87 to 89 are the paragraphs which the CAT relies upon in paragraph 45. So
yes.
That's what the CAT sees as pivotal. If you go back to 68, which is where the court endorses paragraph 53 of carte bancaire as the test, yes, which we've all seen, which has got the 4 references to content, object, legal, economic context.
Yes.
And then 69 and 70, you've got a description by the court of economic contextual matters and legal contextual matters, strong barriers to entry linked to conditions attached to placing of medicines in the market, pricing mechanisms strictly controlled by legislation, strictly influenced by market entry, entry which leads to fall in the sale of prices of medicines, 70, analysis that the sector is sensitive to delays in market entry, maintenance can lead to the maintenance of monopoly prices higher than those which are normal. So those are all broad economic factors. Yeah. Some of them are legal because they relate to regulatory barriers to entry and expansion. And that's the economic legal context in which they are looking at the analysis of the settlement agreements themselves. The settlement agreements themselves involve an analysis of whether the sums paid are a fair consideration for the patents. There's quite a lot of analysis. And then you get to 87. Now that's the end of a fairly long series of paragraphs analysing the context, including economic and legal context. But it's only really round here that you get back to some analysis of the purpose or the objective. So you're saying that this is the test, or do we have to look at everything from 68 onwards in the light of Bank Carter? This is what the CAT viewed as the test, if you like, I think.
Yes.
Let's read it fairly.
Your Lordship fairly summarises the judgment, as I hope I have as well.
Yeah.
But as I've made the point that the court refers, paragraph 71, to the sufficient degree of harm test.
Yes.
And then it mentions certain elements of context.
Yes.
But then it pronounces that the central reason why it concludes that these are restrictions by object is because of the objective intentions imputed to the parties by reason of the amount of money paid. Now, going to the judgment under appeal, you were taken yesterday to paragraph 162, where indeed the judgment says it's necessary to decide whether the contractual provisions in question reveal a sufficient degree of harm to competition to be considered by object. And then, yes, it does say the central question is whether the relevant economic and legal context, whether in the relevant economic and legal context, as agreed and applied, pursues a legitimate aim within the meaning of Pierre Fabre as confirmed and fleshed out in generics. And then it starts, paragraph 164 onwards, with consideration of those carte bancaire considerations. So I would submit that the approach taken by the judgment is not, even if the phraseology is not always ideal in the judgment, is not at variance with what was said in generics. And on the question of assessing context, it's very brief and, dare I say, generic in making these remarks about the nature of the medicine sector. And it's also important to bear in mind that what we're dealing with here is, or the procedural context rather, is that of a reference for a preliminary ruling from the CATS to the Court of Justice. And the division of labour in those cases, as your Lordship will know, is that it's for the Court of Justice to pronounce on the interpretation of EU law, but it's for the National Court, and the National Court is very much sovereign in these matters, to deal with the fact finding. And if we go to page 1077, which is where the court sets out its formal answer to the CAT.
Just on that, I think you make an important point, because the questions which were actually referred by the CAT were quite specific and particular. They didn't really challenge the carte bancaire test, but they described, this was questions 3 and 4 in the judgment, they described the essential features of the agreement in question, and they asked, can this be an object restriction? And then question 4, does the answer differ if the scope of the restriction does not go beyond the scope of the patent in question? And so a lot of the analysis from 87 onwards is really addressing that, what we used to call existence exercise type distinction in old article, free movement of goods cases. Was this no more than the pure existence of the patent being reflected in contract, or was it something over and above that? Isn't that what they're really answering in 87 to 89?
Well, the point about questions 3 and 4, I think your Lordship directed me to, related to the duration of the patent, the scope of the patent. But the court makes some general pronouncements about the nature of the pharmaceutical market in those paragraphs that I took you to, 69, 70. And in giving its answer to the CAT, page 1077, you see that after explaining the factual background, whether the whether the payment is in return for transfers, or whether the agreement, the settlement agreement, is made in return for transfers of value by the manufacturer of originator medicines, constitutes an agreement which has as its objects the prevention, restriction, or distortion of competition, if it is clear that. And so it's giving a very clear answer. It's not inviting the cat to engage in any more fact-finding or contextual analysis, with the point generally that I think we draw from generics is that there are some restrictions which just don't need very much elaboration in terms of identifying why they constitute something that reveals a sufficient degree of harm. Yes. We'll come to more of that when we get to the more recent cases that the court directed our attention to. But whilst we're in generics, I just again go back to Advocate General Coco's. This is paragraph 160 of her opinion, which
160 or 116?
Sorry, 160.
160.
Which begins at page 1022, where she makes some remarks about context, in the context of an argument about benefits from some of these patent settlement agreements, and whether that affected the finding of a restriction of competition. And so at paragraph 160 of her opinion, she says, therefore, as Advocate General Bobek has recently noted, that's of course in Budapest Bank, the examination of the context of an agreement also serves to confirm that the harmfulness of an agreement which, in the light of its content and objectives, is capable of constituting a restriction of competition by object, is not called into question by the relevant contextual factors. In other words, it's necessary, in the light of the information present in the case file, to check that there are no specific circumstances that may cast doubt on the presumed harmful nature of the agreement in question. So that's an example of endorsing a kind of reality check point of view in relation to something which clearly looks as if it is a restriction by object, and it was taken as axiomatic in generics that such an agreement was. I think
the words used in 160, or the word used,
yes,
is the presumed harmful nature of the agreement.
Yes.
So, in a case where the parties, maybe an absurd case, but the parties in their agreement acknowledge in recital 1 that our objective in doing this is to distort competition. Would that, on your case, is that the end of it? Them having admitted that, is that the end of the case?
Well, not entirely. It's well established that one can take account of the intentions of the parties, but they're not decisive. What matters is an objective analysis of what the objectives of the agreement were. Okay. So if the parties say, we're determined to partition the market, we've reached this agreement and we're going to do this, this and this, if actually the agreement doesn't do anything at all of that nature, that preambular statement of intent that your lordship instances doesn't have any weight on the matter.
Because they've misinterpreted their own agreement. But let's assume they haven't. Doesn't the court still need to ask whether the nature of the agreement is such as to be actually harmful to competition?
Yes, one would have to be sure that the parties' stated intentions have been followed through in the substance of the agreement.
No, I'm not saying something slightly different. Not what's in the agreement reflects what they intend, but it doesn't, in fact, have the harmful effect that they thought it might have.
Well, is your lordship
the concept of the impotent megalomaniac?
Well, yes, I think my question back to my Lord Justice Zacaroli is, are we talking about effect in the sense of the other side of the object-effect distinction, or are we talking about what the parties think they're doing? Do they think that they are distorting competition? by their agreement. Whether it has any concrete effects is, as I indicated with that first time I took you to Advocate General Cocott's opinion, not necessarily material. But if the parties say that they intend to distort competition, but, as your lordship posits, content of the agreement doesn't actually do that, then I would submit that there isn't a cause to...
There isn't.
Is not a cause to make a finding of restriction by object.
But isn't that because it doesn't have the harmful effect they thought it would have?
Indeed.
So you've got to look at the harmful effects.
Yes.
In any case.
Yes. I mean, that, your lordship there is positing an agreement where at least the parties have set out what they intend to do. One of the problems of this case is that we have the something of a black hole in the form of Clause 15 in the 2019 email, which are capable of being used one way or another. And what it came down to is how Decker's enforced the vast latitude given to it by Clause 15. So there isn't really very much to refer to in terms of any visible statement of intent. So that starting point of analysis of your lordship's example doesn't arise in this particular case.
But as I understand the case that you have to meet, it's this. An arrangement entered into by an entity with, say, 30% of the market is one which is likely to, which if overtly aims to distort competition in the market, is one which is undoubtedly likely to fall foul of the prohibition. But the same agreement, in exactly the same terms, entered into by somebody with 0.1% of the market, is one which will not distort competition, because it's not just a impotent megalomaniac. Well, it's impotent in the sense of tiny. And my understanding is, stripped down to its very core proposition, is simply that Decker's is not, no matter what it set out to do, it's just not big enough to create harm to competition in the market.
Yes, well, I understand the question and how that arises from the exchanges yesterday, but further to what I said at the very beginning of this morning, there I think we have a basic error of transgressing from object into effect, because your lordship's question, with the counterpoint between the 30% market share undertaking and the 0. whatever share of the undertaking, invites us to take into account market shares as a relevant economic factor of context, and that is essentially the only criticism that Decker's has left of the approach taken by the judgment. It criticises the failure to have regard to market shares.
So when you're assessing harmfulness, to use just the expression that's used in that paragraph 160, I appreciate it's not the one that's used in the main judgment, but when you're assessing the harmfulness of an agreement, what you do it in vacuo. You just look at the terms and say conceptually, is that right?
My lord, yes, it's whether the agreement is harmful by its nature. That's where I'm jumping ahead to some submissions I'm going to make about that very issue. I don't know if I could leave that there for the moment, but it is an important point. If your lordship would like me to deal with it now, I could. Or
Take your own course, whatever's convenient to you.
Well, I think, my lord, it would be better if I
Develop
carried on with some of the cases.
Can I just ask you about one point you made, which I think is on case? You said the error made was to really confuse the test for object with that for effect. That was addressed in Ping by the Court of Appeal, who were quite careful to delineate, if you like, the standard of proof in an object case. And they rejected the notion that a potential or capacity to restrict competition was enough. they said you had to show a sufficient degree of harm, but of course that doesn't mean to say you require ex post evidence of actually what happened. It's always going to have an element of prospectiveness or ex ante analysis about it. That's the big difference, isn't it?
Yes, well, your lordship anticipates me perfectly because I was about to come to Ping.
Well, why don't I leave you to deal with that?
Well, just to deal with that point immediately, it's important always to bear in mind the distinction between the nature of the agreement. As your lordship said in some exchanges yesterday, taking some arguments to their ultimate extent, it would mean that any commercial agreement could be a restriction, or even a restriction by object, because any agreement could have some sort of effects. But whether we are in the object box depends on the nature of the agreement, what it's actually seeking to do. But I submit that the market share of the parties is not a relevant element there, but I will come to that later. I don't need to take you through all the early cases on selective distribution systems because a lot of the work has been done by the tribunal first and then the Court of Appeal in Ping. So going to Ping, which is in volume 1 of the authorities, tab 11, page 376. You've already seen this case several times, so you know the plot. It includes a long section on carte bancaire, so there's no question carte bancaire is fully taken on board. But nevertheless, Lady Justice Rose, as she then was, does not suggest that the older cases and decisions are of no relevance at all. We could start at paragraph 24 on page 384, which you were already taken to yesterday. And as it says there, just starting between A and B, that the Court of Justice has established that some vertical restrictions, such as resale price maintenance and bans on exports between member states, will in almost all circumstances amount to restrictions of competition by object. Then acknowledging that some restrictions, metro-compliant restrictions, may be beneficial to the distribution of goods. Now that proposition that resale price maintenance will in almost all circumstances amount to restrictions of competition by object follows not only from recent practice such as Commission and CMA decisions, but also from older cases for what Deckers and the CMA would regard as the watershed of carte bancaire. In relation to that, I just remind the Court that the Court of Justice follows the declaratory theory, so however surprising some of its judgments might appear to be, they are stating the law as it always has been. And then at paragraph 62 of Ping, if we can move on to that, which is at page 393, Lady Justice Rose refers to the three-stage test, which is adopted here, and interestingly observes further on paragraph 76, at page 397, that there is as yet no bright line between the three stages of analysis that the CAT described in paragraph 94 of the judgment. So in this field, metro considerations do sometimes bleed into the 101 analysis. Then, at paragraph 84, it's clear that Lady Justice Rose does not regard Pierre Fabre and Coty as being explained by the fact that they fell on different sides of the temporal divide of Carpentier, which, as I've said, should not be overstated. Just says that on the facts they are on different sides of the line. That's at the end of paragraph 84. On the facts, Coty clearly fell on one side of the line and Pierre Fabre on the other. So before moving then to, whilst we're in ping, to avoid too much back and forth.
Ping pong, in other words.
Then could I ask you to go forward to page 405?
Just before you go to 405.
Yes.
At the beginning of paragraph 82, Justice Rose says, having identified the restriction on competition inherent in the ISP, the next question is to look at what Advocate General Wall described as experience.
Yes.
What does decisional practice, etc., etc. Now, if a restriction in competition was inherent in the ISP and that was really just the end of it, what's she doing?
Well, she is following the precepts of carte bancaire, where and the other case law that's relevant to identifying a restriction which reveals a sufficient degree of harm by taking account of the fact that experience is a factor in deciding that. Yes, she has already decided.
Unless I misunderstood what you were saying a little while ago, you say you look at the agreement, and if it's inherent in the agreement that it restricts competition, then it's a restriction by object.
Indeed.
She doesn't see it, but that's not what she seems to think. Otherwise, she'd have just said, okay, I don't need to write the rest of this judgment then.
Yes. But one of the reasons why you might say that this is clearly a restriction by object is because of experience. So, yes, it could be, if you're dealing with a more novel situation, it could be that you judge it on its content, objectives, and context. But it's clear from the case law that experience is also a relevant factor.
Well, the experience she identifies, she's going on to about decisional practice, is about what the degree of harm that arises from a prohibition on internet sales. So, I mean, she's not using that subsequent analysis to inform her decision that there is a restriction on competition inherent in the terms of the agreement. She's saying, okay, well, now what prospectively can we envisage might be the degree of harm arising from that prohibition on internet sales. So as I see it, she does seem to be saying, well, okay, first of all, see whether the agreement itself contains something which is capable of being a restriction on competition, and then ask yourself prospectively, without doing the full-blown effects analysis, what impact is that likely to have on competition?
Well, what she says at the beginning of paragraph 82 is having identified the restriction on competition inherent in the ISP. And then she refers to experience and asks, well, what follows in terms of the degree of harm that arises? So it appears that the thinking of the judgment is that to identify, first of all, there is a restriction inherent in the ISP, and then refers to experience as a relevant factor in identifying whether it meets the standard for a restriction by object, and then refers to Pierre Fabre and Coty in that respect. My lords, could I continue to page 405, if I may, which is under the...
I'm sorry, I know we keep on stopping you. Can I just ask you to look at the structure of the judgment Lady Justice Rose here identifies forcing. This is under the heading content. Then it moves to objectives.
Yes.
Then it moves to legal and economic context of the ISP,
Yes.
in which it's this is when one comes down to basic reality checks and so on. But it is a four-stage or four-component analysis. An objective is just one of those.
Yes. Yes. It is, but in terms of the relevance and how one might be informed by experience, that's also dealt with on page 405 under the heading F, Conclusion on Object Restriction, where there are some interesting observations. It's paragraph 108 and 109. We're picking up 108 at letter F. She again refers to Advocate General Val in Coty described how a supplier with a selective distribution network will recognise that the stricter the selection criteria it imposes, the greater the risk of loss of market and of customers. In the absence of market power, the supplier will, in principle, he said, self-regulate its conduct in a way that conforms to the competition rules. That's essentially the argument that's being put here by Deckers. And
could you go, I mean, unless you're going to go back to them, could I just ask for your comments on paragraph 85? Where, again, what Lady Justice Rose is doing is saying, in my judgment, this body of authority or experience establishes that so far as the content of the ISP is concerned, it causes a sufficient degree of harm to merit being classified as an object restriction. Implicit in that is there not, is it's not enough that the content is on its face anti-competitive. You know, there's inherently contains an inherent restriction on competition, what she said in 82. But you have to go on to say, having regard to past experience, is it likely to cause, does it cause a sufficient degree of harm to merit being classified as an object restriction? So she again doesn't seem to think that just the terms of the agreement are of itself enough for something to be classified as an object restriction.
Yes, indeed, as my Lord Justice Green just reminded me, the structure of the judgment that follows from 85 onwards follows the pattern of carte bancaire tests. Now, Lady Justice Rose has already said in relation to the content of the ISP that it does appear to cause a sufficient degree of harm to merit being classified as an object restriction, but then, for the sake of completeness, does consider all of the other factors. So she does follow the requirements of carte bancaire, but as we shall see, the extent to which one is obliged to follow the full panoply of considerations enumerated by carte bancaire is modulated according to, amongst other things, experience. And it may be that the utility of this judgment is that it does consider everything. It goes through the entire gamut of carte bancaire considerations and is particularly useful in that respect. Whether it needed to do that is another matter. And there's a hint that perhaps it wasn't really necessary. On page 405, paragraph 108, where Lady Justice Rose refers to Advocate General Val in Coty, suggesting that there's some kind of self-regulatory mechanism inherent in selective distribution systems. And then commenting on this, says at paragraph 109, for this reason EU competition rules have respected to some extent a manufacturer's choice as to how best to promote its product, but only to some extent. The Court of Justice has never been content to rely only on the kind of self-regulation to which Advocate General Val referred to to ensure that competition is not restricted. Then refers to CMA having referred to Constant and Grundig, one of the old cases, commenting that that judgment established that the court does not regard interbrand competition as sufficient to bring about the optimal use of resources. The competition rules do not rely on suppliers self-regulating by leaving them free to set the terms on which undertakings further down the distribution chain market their goods to the ultimate consumer. The retailer also has a commercial interest and expertise in marketing the goods successfully. Since Constant and Grundig, the dividing line between what is legitimate for the manufacturer to decide and what must be left to the choice of the retailer has been carefully drawn. And then in that respect of identifying how this has been carefully drawn, refers to the block exemption regulation as drawing boundaries between active and passive sales in exclusive distribution networks, between resale price maintenance and recommended or minimum pricing, and now outright bans on internet sales and restrictions which replicate more precisely the boundaries already established for permissible restrictions. So it's interesting that Lady Justice Rose is there referring to the block exemption regulation in her explanation of how there is a dividing line between the freedom of the supplier to do what it will with its selective distribution system and the constraints imposed upon it by Chapter I. My lords, then before moving to ground 2 and how the judgment applied the law to the facts, on this preliminary theme of the general rules governing by-object restrictions, I should address the recent cases and guidance, and the court drew the parties' attention to the opinion in Tondela and the judgment on appeal in Teva, but I would respectfully suggest that we take one step back and include in our consideration another quite recent case, Banco BPN, which is in volume 4 of the authorities at tab 27, page 1454. This, like generics, is another reference to a preliminary ruling of the Court of Justice. Let me say at the outset, it concerns a very different type of restrictive agreement, but it's useful nevertheless because it takes account of all of the recent developments in this area of law. If you look on page 1464, you'll find that there's a complete catalogue of all of the important cases in this field recently. The carte bancaire cases, the pay for delay cases, and the restatement of essential principles of Articles 101 and 102 in the Grand Chamber's judgments in a series of sports governance cases, International Skating Union and European Super League. Now, the questions referred were about some findings made under Article 101 by the Portuguese NCA, National Competition Authority, against banks which were engaged in exchanges of information both as to their future expectations about factors relevant to credit markets and some historic data on credit that they had given. You can see briefly the nature of the information that's exchanged in paragraph 13 of the judgment on page 1491. Essentially, it's two types, current and future conditions. So that's information about relevant to future loan transactions, and then production volumes, as they're called, information about loans that have been granted. And it was the exchanges of information between the banks were found by the Portuguese Competition Authority to be restrictions by object. And then you see on the next page 1492, bottom paragraph 21. So the question that is referred to the court is about whether those exchanges of information could be characterized as restrictions of competition by object. And it's, indeed, if you can go back to the opinion of Advocate General Rantas, which is further back in the document, we can start at page paragraph 37, which is page 1473, where he begins by saying it's necessary to recall that the essential legal criterion for ascertaining whether an agreement involves a restriction of competition by object is the finding that such an agreement or practice reveals in itself a sufficient degree of harm to competition for it to be considered not necessary to assess its effects. And then he elaborates on that a little more, referring in particular, you will see paragraph 38, to the existence of reliable and robust experience as being an important factor, emphasising, however, that the absence of precedents does not prevent competition authorities from classifying a restriction which, following an individual and detailed examination, is found to be detrimental to competition. And then, further on the theme of experience, paragraph 39, the fact that not all the characteristics of an agreement which is the subject of proceedings are identical to the characteristics of a practice which has previously been classified as a restriction of competition by object does not mean that there is not sufficiently reliable and robust experience in that regard. Indeed, to require that all the characteristics of such agreements match absolutely, including in relation to the relevant markets, as some of the applicants appear to maintain, would unjustifiably limit the scope of the concept of restriction by object and make it particularly difficult for competition authorities to apply that concept. That is relevant here in that it chimes with a point made in our skeleton, paragraph 5, that's in Core Bundle 6, page 71, that the categories of restrictions by object are not fossilized. That remark is also consistent with I'm sorry, find my place again. Yes. Then
I thought you were going to take us to AG 40, paragraph 40.
Yes, well, the Advocate General does recall that other principle of the need to interpret the concept of restriction of competition by object restrictively, and that it should be reserved for situations where it's obvious or where the practice has no credible explanation other than to restrict competition on the market. Indeed, that's very similar to what we submit is the underlying logic of generics and what the tribunal had in mind in applying generics when you have a type of restriction that is classically recognised as a restriction by object.
Well, but it was really his comment about classification should be restricted to cases where the anti-competitive nature of an agreement is obvious.
Yes.
I mean, how do you read that? Do you read that as not looking beyond the agreement in a vacuum, or does he mean anti-competitive nature is obvious having regard to experience about how it would play out in the market?
Well,
bearing in mind the fact that this case was a horizontal exchange of price-related information between undertakings with 83% of the market.
yes, those sort of things
It might be an SBO.
are rather obvious. He's not suggesting that one looks at the agreement in a vacuum. A vacuum would be going too far because then there are the carte bancaire considerations. take account of. On the other hand, there is also the point that that there is experience that one can draw on, and in that respect, I draw your attention to paragraph 42, where he says that the main purpose of taking into account the legal and economic context when analysing a restriction is to confirm or invalidate an initial finding that a given practice has an anti-competitive object, which was made on the basis of other elements specific to that practice.
Is that correct? Then that rather puts the formal element of the analysis, content and object, before what might be the most important, which is economic context. I mean, I could see in some cases that it might be an apposite way of describing the facts in front of you. Here, horizontal agreement, 83% of the market, not much analysis is really required. So that's your initial view, and then you look at economic analysis to see whether that gets you home or not.
Well, my lord, I would submit that your hypothesis of an agreement with 83% of the market is already anticipating consideration of that question of economic context.
Yes.
And you have my submission, although I haven't elaborated on it yet, that in any event, whether it's 83% or 8.3% of the market, is not a relevant consideration to the identification of a restriction as a restriction by object.
Yep.
What Advocate General Rantos appears to be doing here in paragraph 42 is warming to his theme about relying on experience, saying, look, if you have something which is pretty clearly likely to be a restriction by object, then the taking into account the legal and economic context is simply a reality check. And as I shall show, that's not an isolated opinion. It's endorsed by others as well. So if, and indeed on that question of legal and economic context, if we could turn on to page 1483.
Well, okay, before you go to 1483, can you go back to paragraph AG 44? Doesn't he make it clear what he's doing there? He actually sets out the examination of the legal and economic context, seeks to avoid the risk of false positives, which may stem from a form-based analysis of an agreement which is detached from economic reality and the legal and legislative landscape in which it occurs. I mean, isn't he there saying, you don't adopt a formalist view of the agreement in the vacuum, you have to actually form an assessment of how it's likely to play out in the market as a matter of economic reality?
Well, my lord, I would respectfully dissent from how it's likely to play out in the market as a matter of reality, because as I said at the outset of this debate by reference to a paragraph from Advocate General Clocott's opinion in generics, we are concerned here with the protection of competition as a process rather than any particular effects that might occur in an individual case. That's the whole point about the restriction of competition by object.
But what he's saying is I'm sort of putting to you, I think, Mr. Mishu's point, which is you want to avoid what he calls false positives.
Yes.
I.e. agreements which, at least if you looked at the form of the agreement, are plainly capable of having, as it were, an anti-competitive aim, but which, as a matter of economic reality, given who's entered into it, won't shift the market a jot.
Yes, if one is thinking of a very complex and sophisticated agreement, that has some force. But I had just to come back to the reality of the present case. There's nothing very sophisticated about what's going on here. I think also to put paragraph 44 in context, we should indeed look at paragraph 82 of his opinion, where he's expressly considering legal and economic context. So Your Lordship has drawn my attention to the reference in 44 to the examination of legal and economic context of being there to avoid false positives. But let's look at what he says a little further on about legal and economic context. This is page 1483, paragraph 82, where he says it should also be recalled, as I stated in point 47, that where the anti-competitive object is easy to perceive, as appears to be the case for exchanges relating to credit spreads, the analysis of the economic and legal context in which the practice occurs should be limited to what is strictly necessary to ascertain whether there are any particular circumstances capable of giving rise to doubt as to the harmful nature of that practice. And so he limits the elements of analysis of economic and legal context to those which are truly relevant, as he explains, and that the competition authority is not required to examine arguments which are purely hypothetical or distinct from the legal and economic context in which the exchange takes place. So that puts legal and economic context in context. And I think in view of the march of time, I would like to take you straight to the judgment in Banco BPN, where we can pick it up at page 1496 and paragraph 45, where the court explains that one has to consider whether the collusion here between the banks has the characteristics enabling it to be linked to a form of coordination which must be regarded by its very nature as harmful to the proper functioning of normal competition. I just pause there to emphasize that the expression used is the proper functioning of normal competition. So we're concerned, as I say, with this higher concept of competition, which is the case, in particular the case if any coordination exhibiting such characteristics is precisely because of those characteristics capable of creating conditions of competition which do not correspond to the normal conditions of the market in question. So it's a fairly broad category of what might be a form of coordination which reveals by its very nature sufficient harm to competition. And then I think, again at paragraph 46 on legal and economic context, the court stresses that this in no way requires that the effects of that agreement, be they actual or potential, negative or positive, be examined or a fortiori proven. And then echoing what the Advocate General said at paragraph 82, the court says something very similar at paragraph 48, where it says that it may be that it is only where certain specific conditions are satisfied that it can be presumed that certain forms of coordination are harmful, but then goes on to say that the purpose, towards the end of 48, the purpose of taking the context into account is thus to ascertain that no particular circumstance surrounding the agreement, decision or concerted practice at issue is such as to rebut the presumption that the form of coordination to which it belongs is harmful to competition. And then there's a remark in paragraph 49 which I should refer my Lord Justice Zacaroli to, because I think it's useful in answering that question that Your Lordship put to me about parties who have a subjective but misguided intent in Your Lordship's example, and what do we do with that? And the judgment there says that the fact that undertakings acted without any subjective intention and the fact that they pursued legitimate objectives are not decisive. So the intentions, their subjective intentions, whether they be one way or the other, are not decisive, but they can be taken into account. Then I think I should come to Tondela.
And you made the submission that you don't think market share is relevant.
Indeed.
In this judgment, the court treats as relevant the fact that the exchange took place between the main players in an oligopolistic or at least highly concentrated market, and there were barriers to entry. This is paragraph 58. Isn't that really another way of saying high market shares for all parties? It's the latter half of paragraph 58. And 59.
Well, here this is in the context of examining the objective aims, it appears from the beginning of paragraph 56, as regards the objective aims. So, and it's making the point that the exchange of information is harmful to competition because the players.
I think 58.
Notice of it.
It's not 50. I think this is following on from the first two lines of 58. Necessary also to take account of economic context. So it's an also.
Yes. Well, that's to deal with an argument that the banks would be suggesting that, well, they had this information exchange, but they didn't do anything very much with it. The court says here that the court is using the fact that these are the main players in an oligopolistic market to make the point that it would be rational to have no fear about the reaction of potential competitors, because it seems there aren't really any outside the circle of those exchanging information, or consumers, because they'll have nowhere else to go. So it's saying that an exchange of information looks like a restriction by object, and the economic context confirms that. But it's a very general statement made about characteristics of the market. And again, I'd make the point that the facts of this case are very far removed from those that we're concerned with here today. But the case makes a number of useful and illustrative points about the nature of the inquiry needed to satisfy the requirements for establishing a restriction by object. The Tondela case, as was discussed yesterday, the judgment is unfortunately still pending because it's linked to some other cases, I understand. And the Advocate General's opinion is all we have for the moment. It has some parallels to the present case in that if you look at paragraph 4 at page 1508, and paragraph 5, it's about what Portuguese football did to react to the COVID outbreak. And as explained at paragraph 9, there were discussions between the Players Association and the Football League, and an agreement about extending contracts to the end of that season, whenever it might end, in view of the cessation of football at the time. But there was no agreement on salaries. And then paragraph 10, the Football League announced that no player would be taken on by another club if a player unilaterally terminated his employment with his old club. The facts are not entirely clear, but it appears to be the case, from having looked at the reference made by the Portuguese court, that the concern was that since players could not play because of COVID restrictions, they could invoke the fact that they were not allowed to play by their club as a just cause for terminating their contract, and then there could suddenly be lots of players shuffling from one club to another, which the Football League was very keen to avoid. And moving on to the nub of the matter about restriction by object, you see at paragraph 25, the Advocate General sets out what he's trying to do in the light of some significant judgments given by the Court of Justice, such as those on the list that I directed your attention to in relation to Banco BPN. And the Advocate General says, it seems to me three main considerations are behind that case law: avoiding formalism in the definition of by-object restrictions, ensuring a restrictive interpretation of that concept, and establishing a clear distinction between restrictions by object and those by effect. And then coming back to my theme about what we mean by sufficient harm to competition, as the Advocate General says at paragraph 27, the expression sufficient degree of harm should not, however, be understood as a quantitative threshold. And that paragraph ends by referring to certain types of vertical agreements with a footnote which takes you to super pop. And it goes on to say that the term sufficient degree of harm should thus be understood as relating to a qualitative characteristic of the agreement. To constitute a restriction by object, the agreement must have a manifest anti-competitive economic rationale, and then there's a section over the page, 1512, which is ambitiously entitled How to Establish a By-Object Restriction. And again, attention is given to this question that is a preoccupation of the court about economic and legal context, and the requirement to take that into account is recited. And the Advocate General concludes that it mostly depends on the circumstances of the specific case. And he mentions as economic factors existence of barriers to entry, market concentration, competitor strength, suppliers and buyers, countervailing power, and so forth.
That would include market share.
That would include market share, my lord, but he says it mostly depends on the circumstances of the specific case, whether you need to take any of those factors into account. And he gives the example in paragraph 36 on that there will be a modulation between how much you need to take into account these things depending on the circumstances of the case. And I think I must move on rapidly, because then we have another section called How to Establish a By-Object Restriction, Chapter 2, page 1513. And here we see, as a counterpoint perhaps to legal and economic context, the experience coming into play. This is paragraph 41, where the Advocate General says a first and more traditional line of analysis is typically adopted where the agreement in question appears to belong to a category of agreements whose harmful nature is well known and generally accepted. For example, price fixing, output limitation, and market sharing. In those cases, experience, that is, economic analysis and past administrative and judicial practice, confirms that the agreements are usually anti-competitive. And so he goes on to say at paragraph 42 that accordingly, where the examination of the content of the agreement reveals that prima facie the agreement constitutes what is often referred to as a naked restriction, an expression borrowed from Article 102, I think, then the examination of the legal and economic context and of the objectives of the agreement need not always be very detailed. That's very much aligned with what I just took you to in Banco BPN. And then paragraph 43, the envisages a second type of analysis for agreements which are not safe prima facie by object restrictions, for example, because they have significant original features. Then we needn't be concerned with the actual facts of this case, because it's about no poach agreements in the context of football, which is far removed from where we are now. And so I think I should move on to see how this has been put into practice through two CMA decisions of 2020 and 2022, so quite recent. And the first is Roland Drums, which is in the same volume of the authorities if you're working off the bundles. It's in volume 4, tab 30, page 1547. And this is about retail price enforcement by Roland Drums in the market for electronic drum kits. And I think we could start at paragraph 4.1. Leave aside the facts. It is a resale price maintenance case, but the manner in which resale price maintenance was enforced was different. I'm not pretending there's a parallel to that extent in this case, but it's interesting nevertheless to see what the decision says about the legal principles in relation to resale price maintenance. And paragraph 4.1, beginning the legal assessment at 1637, says this section sets out the CMA's legal assessment, and for reasons of administrative efficiency, it's just going to focus on one of the resellers. So not looking at what Roland did with its entire network, but just taking as an exemplar a party called Reseller 1. It suspects that there were other resellers affected by this. That's paragraph 4.2, but they are not specifically addressed. And then I think we can move on to paragraph 4156. Which is at page 1686, which just recalls the object-effect distinction, and that it's not necessary to prove that the agreement has or would have any anti-competitive effects if it can be characterized as a restriction by object. And then dealing with the conduct in question, on the next page, 1687, we have under the heading Resale Price Maintenance that this is expressly identified as a restriction under Chapter I, Section 22A of the Act. And paragraph 4162, referring to the vertical guidelines issued by the CMA, relevant at the time, says that it's an agreement having as its direct or indirect object the establishment of a fixed or minimum resale price or a fixed or minimum resale price level to be observed by the buyer, and that RPM has been found consistently in EU and national decisional practice constitute a restriction of competition by object. And then there's a footnote to a very long list of Commission and other EU national competition authority cases, and it also recalls, even though we're well past carte bancaire here, temporarily, a Court of Justice decision, Binon, about RPM. RPM being a restriction of competition by object. Then, mindful, however, of Carpentier, we do have an assessment starting at page 1693, setting out the content of the agreement. So this being introduced at paragraph 4, 180, saying that for the reasons set out below, the CMA finds that the object of the agreement was to prevent, restrict, or distort competition through RPM, and it was therefore, by its very nature, harmful to the proper functioning of normal competition. Again, that's taking what I submit to be the correct approach to the concept of competition when one is addressing whether there's a restriction of competition by object. And then at over the page on 1694, paragraph 4185 reminds us that RPM has consistently been found to have the object of restricting competition. 4191 on the next page, 1695, is on legal and economic context of the agreement. It's a very short section. It's the bottom of that page, and just over the top of page 1696. It's partly done by a renvoi to earlier sections. Those sections themselves are very short. For example, the section on the goods affected, that's referenced by footnote 562 to section 3B1. If one looks at section 3B1, it's back at page 1561. Well, it consists of just one paragraph, actually, paragraph 3.9, which tells us what the value of the musical instrument sector is, and gives an estimate of the value of percussion sector. So there's not very much there. And then at paragraph, coming back to page 1696, paragraph 4192.
Can I just ask you, I'm just looking back at pages 18 to 25 of 3B, which is the economic and analysis section. A lot of it's redacted for confidentiality. I suppose it's difficult to know what was and wasn't taken into account. But the point is, there was an analysis of economic context. Whether it was right or wrong is neither here nor there, is it? There was an analysis of it. That's what's referred to in that very short section you just identified, at 4.191. The footnote says see 3B1 above, and that's about 7 or 8 pages of findings of fact about the market.
Yes, it's identifying how the market is structured. As your lordship says, there are many redactions, but if you're interested in that section, could I just draw your attention?
I'm not particularly. I'm just
well,
I'm just looking at the approach adopted as much as anything else.
Yes.
The facts may or may not matter, but
yes.
You said it's a very short section. It's not terribly long when you go back to 3B, but it is there.
Yes, it is there. Well, I was just giving one example to what CMA refers in this section on legal and economic context of the agreement. To be fair to the CMA, they do refer. I think it's the next bullet point: market conditions, section B, 3B3, and 3B3 is very short indeed.
Yeah.
Indeed, no, they don't refer to 3B2, but they do refer to section B generally, so I don't think anything turns on that. But if you take section 3B3, to which they do refer, this is page 1564, then there you have it, paragraph 318. According to Roland UK, its main competitors are, and then it's redacted, but it's obvious from further on that it had quite a number of competitors on this subject of market shares. Let's turn then to page 1700, where this is in the context of appreciability, which doesn't arise here, but there's some useful information in paragraph 4211, where Roland is described as holding a significant share of the market, although its estimate is said to be at least 10 to 15%. It's not radically out of line with what we have in I think it's paragraph.
No, I agree. I mean, there's a hint that it's reasonably concentrated. 3 or 4 have between 30 and 40%. You get some economic conclusions at 334. I mean, it may not matter whether we think it's a good decision or a bad decision or how it compares with the cat, but there was an analysis of market share, and they came to the conclusions that preventing the MI reseller's ability to determine resale prices was likely to, and then reduce price competition, reduce downward pressure on retail prices. And that's within the product market or in the defined sector.
Yes, but in any event, the market share is not spectacular.
No.
We're not talking about anything comparable to a monopolist
No, I
with
agree.
a patent on a drug. It's quite modest.
I mean, it comes back to a point you made yesterday, which is, in a sense, it's quite an important point. You started by emphasising that this might be viewed as all really quite wicked. It's resale price maintenance of a sort.
Yes.
And then one said it would be surprising if the law let it go, to which the answer is, well, the answer will depend on the facts, and if the law says it's unrestrained, then so be it. If it isn't, it isn't. This is a case where the CMA found that it was to be restrained because of economic and legal context.
Yes.
Maybe marginal, but...
Indeed, but even taking account of those sections to which we've just been referring in section B, the analysis of legal and economic context is nevertheless very brief. The actual conclusions reached by the CMA, this is paragraph 4.192, page 1696, is simply that the legal and economic context in which electronic drum kits are supplied means a restriction on the price restricts competition by its very nature. This is based, among other factors, on the ever-increasing importance of the internet as a retail channel and the fact that product pricing is one of the main factors on which musical instrument resellers compete. Well, you could say that about almost any consumer goods these days. And
but it isn't what they're doing, is that they say, look, is by its nature this restriction capable of having an effect on competition? And I wasn't sure what paragraph you were reading from there, but it sounded as if that's their view on the nature of the agreement. But then in rides legal and economic context,
yes,
to say, well, does that negate that sort of prima facie view?
yes,
And one of the factors that might negate that prima facie view is that this is an agreement between tiny players.
yes.
Is that a legitimate approach on the authorities?
I don't think that the decision is going so far as to say does a tiny market share in this particular case negate that approach based on, as it's put in some of the cases I've taken you to, a presumption that one is faced here with a restriction by object. Indeed, that modest market share is described by the CMA as significant, and we don't have full information about it because of the redactions in the decision, but clearly, as I've submitted, 10 to 15% market share, whilst not insignificant, is not particularly remarkable.
One of the facts in this case are that, I mean, no one's going to say that Decker's is tiny. It's a sophisticated SME with with obvious skills in its sector, as is up and running. But the market shares are in the 4, 5, 6%, and there are 10 companies, all of that range. So it's not tiny. It's a significant company. But in terms of market structure, you're looking at what we would all, as competition lawyers, say is an inherently competitive structure. A significant number, 9, 10 players, all of whom have between, say, 5 and 10% of a market.
Yes.
That's going to give a pretty low concentration ratio, isn't it?
Yes, although I must make one factual correction to Richard's description of Deckers as an SME. Deckers UK is part of a large group quoted on the New York Stock Exchange with a $4 billion turnover.
Yeah. But I mean, it almost makes the point. We're not concerned about the absolute size of a company. We're concerned about its place in the defined product market. You can have very sophisticated players, part of broader international groups, who are relatively small in the defined product market, which is UK specialist running shoes at wholesale and retail level. We've got the market shares. I understand that they're not seriously in dispute.
Yes. Well, as I've indicated, it is an important part of my submissions that the significance of the market share is being greatly overstated in the debate, and that a modest market share in this context is no barrier at all to finding of a restriction by objects, because what one is protecting is competition as a concept, as much as any particular consumer or other commercial interest in the market. And then the second CMA decision that we're concerned with is DAR lighting, which is in the next volume, Authorities 5. And this is another resale price maintenance case. And just picking up on the Lordship's theme about market shares, though, you'll see here, if we begin at page 1753, so it's tab 31, the first one in that volume. And as you see from paragraph 318, that it's the market that we are concerned with, which is domestic lighting products, is worth about 650 to 700 million a year. And then if you turn on through to page 1754, then you see that 1754, 1755, DAR lighting's turnover in these products was about 24.4 million in the relevant period. Not very much at all. Whilst we're on page 1755, it's noted that paragraph 325, online retailing has significantly grown in importance in the UK in recent years, more so than ever during the COVID-19 pandemic. And then moving on to paragraph 373 on page 1769, you see some of an example of the practices under examination. It's by no means a comprehensive catalogue. I don't think there's time for all of that, but you see at 373 there are restrictions on the use of brand names and logos, product photography, and that at 373.1 that retailers are not to include any links, images, banners, pop-up windows or text which may, in the opinion of the supplier, negatively affect the brand or image of the supplier. And as is described in the decision, that discretionary power, as we have there as we have here, was used to inhibit the use of online advertising for discounted products. And then at 375, just over the page 1770, the observation is made that the above provisions may not have given rise to competition law concerns in themselves, where implemented and enforced in a competition law compliant manner. However, DAR's implementation and enforcement of the SDAs, or the brand guidelines, created a perception amongst resellers that the SDAs allowed DAR to prevent discounting. And you see evidence about DAR not wanting to be seen as a discount brand, for example, page 1789, paragraph 3139. So there's an echo here of what we're concerned with in this case. Then turning to the legal questions, here we move on to paragraph 4250, which is at page 1937, under the heading of objects of preventing, restricting or distorting competition. And the relevant legal principles, which are all very familiar to us now, are set out. And then over the page 1938, it goes to the specific restriction that we're concerned with here, which is RPM. And at paragraph 4.258, it explains that RPM is defined in the vertical guidelines as agreements that have their direct or indirect object the establishment of a fixed or minimum resale price, and again reminds us that RPM has been found consistently in the UK and elsewhere to constitute a restriction of competition by object, and again you have an impressive number of cases cited in the footnote with reference to a number of commission decisions from the post-Carte Bancaire era. Then paragraph 4.286, we have the legal and economic context of the agreements. Again, it's very similar to Roland Drums, and the part that actually makes the analysis is again very, very similar to Roland Drums and is equally terse. It simply says that the CMA considers that the legal and economic context in which lighting products are supplied means that a restriction on the price at which the relevant products can be advertised or sold online restricts competition by its very nature. And this is based, among other factors, on the ever-increasing importance of the internet as a retail channel, and that product pricing is one of the main factors on which resellers compete.
This is an RPN case.
Yes.
Which seemed to be treated as a sort of a breed apart. You know, that's a type of anti-competitive behaviour which is almost treated as in and of itself anti-competitive or an infringement. Sorry,
I don't know, my lord, if I should go so far as to say it's in and of itself, because this decision, like the Roland Drums decision, does refer to the Carte Bancaire criteria and does deal with them, albeit in extremely summary form. But your lordship is right that RPM is one of those things which is, as it says in this decision, almost always a restriction by object. So here we're going back, we needn't turn it up, but just going back figuratively to Advocate General Emiliu's opinion in Tondela. We're talking about one of those cases where the examination of economic and legal context can be very summary indeed. There are also some interesting points in the section which is on penalty applied to DAR. this is paragraph 532 at page 1965, where there's a heading, specific circumstances relevant to the extent and likelihood of harm to competition in this case. Now, this, I stress, is not in the decision as an essential element of making the finding that there was a restriction by object, but this is in the section which begins on the previous page, saying calculation of penalties. So it's looking at how serious was the infringement for the purpose of assessing the penalty. And 532 refers to some of the characteristics of the situation, that many, amongst its top 20 resellers, almost all sold online or in a combination of online or in store, and that the ability to sell at discounted prices on the internet can intensify price competition between resellers due to the increased transparency and reduced search costs from internet shopping. And further, this is at the end of 532, the CMA considers that preventing or restricting the ability for resellers to determine their own online resale prices is likely to reduce price competition and in turn undermine a key benefit of e-commerce. And then 533, which goes to DAR's market share, which, as we've seen, is very small indeed. And but the CMA says it considers that a purely quantitative market share analysis in a market which is fragmented potentially understates DAR's significance as a supplier on the basis of resellers' testimonies. And I'd simply glance back figuratively to Mr. McFarlane's witness statements, where he emphasises how important the Hocker brand was to his shops, focused as they were on very serious runners, and that shoes with the technical properties of Hocker were particularly valued.
They're looking here at relative market shares. That's the point that's being made, that even if it's in absolute terms relatively modest,
yes,
the rest of the market is fragmented, comprises a large number of small firms, and that understates the significance as a supplier. So it's an analysis of relative market share in what appears to be a pretty dispersed or atomistic market.
Yes, well,
But market share is relevant, and relative market share is relevant.
Well, yes, the relative, well, this is relevant for assessing the seriousness of the infringement and the penalty that is to accompany it. But
Yep.
That's that nevertheless it remains the fact that it's a very small market share, and that does not, however, inhibit the CMA from finding that there's a restriction by object here. So if you have that bundle open, in other words, you do, there may be a convenient moment to turn on in that bundle to tab 34, which are the Commission's vertical guidelines of 2010. So those are the relevant ones here. And the court was taken to this yesterday by my learned friend, and we could begin at page 2068, which is point 23, top left of the page, where there's an explanation of the safe harbour created by the block exemption. And it explains it's not safe for everybody, because although it begins, as Mr. Dimitri read out to you yesterday, that the most vertical expense competition concerns can only arise if there's insufficient competition at one or more levels of trade. That is to say, if there is some degree of market power at the level of the supplier or the buyer. What comes next, however, is also very important, which you weren't taken to, which is where it says, provided that they do not contain hardcore restrictions of competition, which are restrictions of competition by object, the block exemption regulation creates a presumption of legality for vertical agreements. And then similarly, the court's taken to page 2097, and to points 176, 177, with emphasis being laid on the comments made at 177 that the market position of the supplier and its competitors is of central importance in assessing possible anti-competitive effects, as the loss of intra-brand competition can only be problematic if inter-brand competition is limited. But this needs to be seen in its proper context, which is explained by going back to 96 of the guidelines. This is at page 2082. Which is headed at the bottom left, enforcement policy in individual cases, the framework of analysis. It says outside the scope of the block exemption, which is what all the rest of the subsequent guidance given is about, it is relevant to examine whether in the individual case the agreement falls within the scope of Article 101, Paragraph 1, and if so, whether the conditions of Article 101.3 are satisfied, provided that they do not contain restrictions of competition by object, and in particular hardcore restrictions of competition. There's no presumption that vertical agreements falling outside the block exemption, because the market threshold is exceeded, fall within the scope of Article 101 or fail to satisfy the conditions of Article 101.3. So that's what these paragraphs at 176, 177 are addressing. They're posited on there not being a restriction of competition by object. And that's a very important qualifier to the comment at point 177, that the market position of the supplier is of central importance. So, Lord, I think I should come to address ground 2 on harm to competition. And here, ground 2 is set out in Decker's skeleton, paragraph 55. Where it introduces ground 2. This is in core bundle tab 5 at page 57, where Deckers avers that the tribunal failed to carry out a proper consideration of the object question in accordance with the Cap on care, and further, having identified the object as being to preserve the integrity of its selective distribution system by controlling the emergence of inconsistent channels of distribution, the tribunal wrongly characterised this as an anti-competitive object. It is not the preservation of the integrity of a selective distribution system, it is generally pro-competitive. Now, that in my submission does not take the appeal anywhere, because in this context, integrity is a content-free expression. Similarly, inconsistent. Inconsistent with what? From the starting point that we have here of a non-metro compliant selective distribution system, that just doesn't advance Decker's case. It doesn't challenge on appeal, as was confirmed yesterday, the finding that its distribution system is not metro compliant. So what are we left with? We're left with the implausible configuration of a distribution system that lacks the objectivity and proportionality required by metro, and on the facts found included 2 specific restrictions of competition. Yet, according to the appeal, Decker's notions of integrity are sufficient to eliminate any infringement from the terms of the distribution system as examined by the judgment. Now, if, as the judgment found, the integrity of Decker's selective distribution system did not include respect for Chapter I, then the complaint about not allowing it to exercise control over inconsistent channels of distribution is an admission. It's not a line of defence. I say if, as the judgment found, Decker's distribution system did not include respect for Chapter I, but one of the puzzles of this case is that even on Decker's premises, I'm not sure I need to add that qualifier. To explain this, your Lordships will recall that when permission to appeal was given, my Lord Justice Green ordered that the parties prepare a statement of facts found, and that's in the end of the core bundle at tab 17, and might be useful just to look at it briefly. So it's at the very back of the core bundle. So it's page 200. Core bundle, yes. It's page 248 of the core bundle. And there's some explanation of the parties' methodology of the last bullet point there, explaining that the evaluative judgments contested by Deckers are indicated in purple, consistent with the Lordship's direction. And you will see, you read through it, that the purple passages, so to speak, are paragraph 120, subparagraph 5, it's on page 250, 133, that's over on 252, 139, page 253, and 146, page 254. And they are variously about the expectation that clearance stock would not be disposed of in a way that adversely affected premium positioning of the current season stock, that's paragraph 120, subparagraph 5, and then avoiding losing control over clearance selling, that's paragraph 133, and preventing the emergence of alternative sales channels inconsistent with Decker's conception of its selective distribution system, that's paragraph 139, and paragraph 146, that the prospect of discounting on running shoes, the second website that Up and Running asked for permission to set up, was a real concern to Deckers. These are all very similar. The essential thrust is that these are findings that Deckers was using its online sales policy to prevent members of its selective distribution system from discounting on clearance sites that they might want to set up. The court's instruction was that skeleton arguments should justify challenges to such findings. Well, Decker's skeleton, far from justifying its challenges to the indicated findings, in fact appears to endorse them. The very nature of the second ground of appeal is in that vein. It takes issue, that's well understood, with the legal characterization, but as to the facts, no. There's a retreat to generalities, but there's no challenge to the factual finding made in, for example, paragraph 139, that it's plain that the control imposed by clause 15 and the 2019 email was designed so as to allow deckers to restrict the use of alternative sales channels not consistent with the selective distribution system.
Sorry to interrupt, but just in case it helps, we don't contest that. It's impermeable, but I don't contest.
Yes.
You made clear that there's no issue of fact on this appeal.
Yes, I'm grateful for that clarification. I was going to say that it appeared to us that from the exchanges yesterday that was now clear, that there is in effect a renunciation of any challenges to any findings of fact. There's challenges to the legal conclusions drawn, so I don't need to pursue those.
This was why I was so anxious yesterday to try and delineate precisely what the facts added up to.
Indeed,
which is, I think, quite important for us.
But we're left then with something of a puzzle. I take it that it would appear from yesterday's exchanges that there's even no challenge any longer to what is described in Decker's skeleton, paragraph 72, as the finding of fact that is absolutely essential to the judgment, namely the central economic assumption that retailers could not discount as much as they would want to on their own store website.
That obviously is challenged.
Yeah.
Sorry to interrupt, but just to be clear.
Well, but my learned friend has just said that the purple passages are not challenged, but those are entirely consistent with what I thought appeared to be an acceptance that Mr. McFarlane's explanations of why he needed the Running Shoes website, that was now accepted. There was an exchange yesterday between my learned friend and my Lord Justice Snowden, when Lord Justice Snowden put it to Mr. Mitriou, if I recorded it correctly, that a retailer was never going to do deep discounts on his own store website. And Mr. Mitriou said correct. And then there was an exchange with my Lord Justice Green about paragraphs 142 to 144, which again appeared to be accepted. Now I'm quite happy to address the point about Mr. McFarlane's evidence that discounting on up and running was just not commercially feasible. But yes, it would be useful to know where we are on that, because it appeared from the exchanges yesterday that these facts, including notably...
which fact, particularly in the judgment, do you now rely upon, which you are trying to hoist the appellant on? Which particular fact?
Well, the fact...
in which paragraph?
The finding... Well, one, the critical ones, it does say in Statement of Facts, tab 17, where we have paragraph 133 in purple and paragraph 139 in purple, that the reasons for this in relation to paragraph 139 follow in subparagraphs, and there are many subparagraphs to 139 in particular. So the paragraphs that we need to rely on are those relating to the necessity for disposing of clearance stock through a secondary website. That was the explanation given by Mr. McFarlane. So that, if we go to...
So 139 is only about control of alternative sales channels, anonymised websites.
Yes.
That's not about pricing.
Yes.
133 was about the degree of control. And although it goes on to talk about pricing later on, in relation to up and running, that's a fairly broad statement about degrees of control.
Yes. Well,
I mean, one of the reasons we asked for clarification is to see the extent to which, in particular, 142 to 144 were disputed or not disputed, because they're a curate sec. They help both sides in different ways. And for us, it's helpful to know if those findings of fact are treated as the givens for our analysis, or whether or not they're in dispute. But we understand 142 to 144, for the purpose of the appeal, are not in dispute.
Well, indeed, hence my perplexity, because, for example, 142,
Yeah.
which your Lordship pronounces is not in dispute, says we find that Decker's actions were an attempt to discipline up and running and prevent it from entering the clearance channel and thus pricing Hoka product at the lower levels it wished to.
Yes.
Well, that's only comprehensible if one proceeds on the basis that pricing Hoka product at the lower levels it wished to is contingent on being able to set up being able to set up the running shoes website.
Well, I'm not certain. I mean, 143 rather qualifies it.
Well, that's Decker's perspective.
Well, this is what the last sentence, we accept that evidence. So that's the important thing. From our point of view, it's treated as accepted by the tribunal, and that it's substantiated by contemporaneous documents and compliance training. So we construe that as the CAT adopting that as, if you like, a fact.
Yes. I think the best way to answer your question is that if we go to paragraph 72 of Decker's skeleton, they complain that the tribunal considered it to be obvious or self-evident that it was not realistic to discount heavily on the up and running website, and that's at paragraph 139, 1 of the site, and 139 is one of the purple passages. So if I go to 139, yeah, so it's that Mr. McFarlane, this is paragraph 139.1, page 198, where essentially the tribunal is accepting Mr. McFarlane's evidence on this, saying Mr. McFarlane explained to us that to do so, let's say heavily discount on the up and running website, would cause customer discontent, and in his case, franchisee discontent as well. He was criticised by Ms. Berridge for providing no evidence to support this assertion, but in our judgment, it was a logical and sensible point, and we think it likely to hold true for retailers generally, and that seemed to be...
But where does this ultimately take one from our perspective? If we take the facts as found, particular 142 to 144, we would start with the proposition that we're analysing a situation in which Decker's disciplined up and running,
Yes.
or engaging in an anonymised website upon the basis that Decker's did not want it to unduly discount prices. That sounds stark, set against what's found as a fact in 143, that there was no restriction on price discounting either through bricks and mortar or through non-anonymised, branded websites. Yes. And this was a restriction only applied to up and running. So just if we add up and tot up in a very mechanical way the facts as found, it swings both ways. There is a sort of restriction, may not be traditional resale price maintenance, but it's only through one form of website. It's not all websites or all discounting or all products or all retailers.
Well, I think your Lordship has my submissions on that. This is an inevitability of the fact that we're concerned with a private action brought by a Decker's retailer.
I get that, we understand that, but if the facts had been this was a policy applied to everybody in all circumstances, all outlets, bricks and mortar, all websites, all goods, then you'd have been more in line with some of the case law of the European Court that we've seen, Superboc and Pierre Fabergé and so on. But that's not what they found in 142 and 143. It's a much more mixed picture.
They're not making any findings about anything else for two reasons. One, because of the nature of the action. It's a claim by up and running, not some sort of collective claim.
No.
Then there's also the problem that what might have been going on at the relevant time, one can't be sure what's going on at the relevant time, because if they can directly...
Well, we don't know that. All we can go is on the findings of the CAT.
Yes, but the CAT was particularly unimpressed with Decker's approach to retaining evidence.
Yeah.
This is paragraph 115,
Yeah.
116. And so, for those two reasons, the missing evidence and the very nature of the proceedings, this being a claim by up and running, then, of course, the CAT is only dealing with the case before it, which is about the restriction imposed on up and running. But in terms of identifying what is contested and what is not contested, well, yes, it appeared to us that on the logic of the second ground, and in particular in the light of the exchanges yesterday, that the purple passages had gone, but I understand that it's still contested as regards the underlying logic of not being able to discount on the up and running shop website itself. That's it at paragraph 139.1.
The point is perhaps most clearly put in 203, isn't it? Also identified in the skeleton.
Yes.
It was inevitable if up and running were permitted to sell residual stock on a clearance basis, it would do so at prices materially lower than on its store or its own website. That must have been obvious to Deckers. That's the critical finding, isn't it, which you bank.
Indeed. Now, yes, to be fair to Deckers, in trying to elaborate this statement of facts, we took it for granted that everything in section H of the judgment, which is where paragraph 203 lies, was at least potentially being contested, but paragraph 203, which your Lordship draws my attention to, is of course posited on the factual findings made earlier, which were contested in terms of the statement of facts and issue, statement of facts, but I would submit that the very logic of the second ground is that it's unclear why that's contested, because paragraph 139 of the judgment is specifically identified in paragraph 55 of Decker's skeleton, and says that the tribunal wrongly characterised this as an anti-competitive object. And what it's wrongly characterised is, according to Deckers, the steps it took to preserve the integrity of its selective distribution system. And
But we will proceed on the basis of the facts as found, whether, even if that's true, which it could be, and you could still have an attempt to control price because you believe that undue discounting undermines the integrity of the system.
yes,
We proceed on the basis of applying the Bank-Carter test to a set of facts which assumes that the termination was because of a concern over undue discounting, but in the context that that only applied to the one retailer on the anonymised website and was not otherwise applicable.
indeed.
So when we're looking at economic context and significance, that would be our starting point. And we take into account what's said in 203, which is a finding of fact.
Right. Well, I'm grateful for that clarification. Just if we're on this question of Mr. McFarlane's inability to discount on up and running, simply just very briefly, the point out this was central to Up and Running's case from the outset. It's in his witness statement, which is in the supplementary bundle, tab 19, page 239. 239 is the relevant part, where in the middle of the page, paragraph 122, he explains that while we did occasionally offer sales on the Up and Running website, we have never and would never sell as much discounted stock on Up and Running as we did on running shoes. It was therefore essential that we had the second site in order to sell the older stock. And so that's very clearly set out in his witness statement. And Deckers, of course, had the opportunity to reply to that, and reply they did, with a second witness statement by Mr. Hager, which is at tab 17, page 160 in the supplemental bundle.
Sorry, that paragraph is not talking about cost, is it? It's talking about volume. They wouldn't sell the same. They wouldn't want to sell as much stock.
Yes.
On their own website. Not that they're using the clearance website to sell at a lower price. They're using it to sell more stock than they otherwise would have done.
I don't think there was ever any discussion about precise price levels, but recall the factual circumstances. Up and Running had a massive overhang of what was fast becoming old stock, clearance stock, and the impending arrival of new stock, which had to be financed. And so they had to get rid of the older stock. Yes, he's talking very much about the volume, but as you will see, I can perhaps take the court to Mr. McFarlane's explanations of this in his evidence of trial, where the issue is explored. But I think it may be best if I'll come to what was done at trial. But before we get to the trial, just in terms of the witness statement evidence, so there is a reply witness statement by Mr. Hager, and he says indeed, this is page 160, paragraph 2, I've been asked by Deckers to provide this second witness statement in response to certain factual assertions contained within the first witness statement of Dennis McFarlane. So what is the response? Well, on this issue, there isn't one at all. There's no response in there. It's quite a short witness statement. And he, in his comments on the Running Shoes website, he says in the last page of his witness statement, page 163, it was paragraph 13, it was clear that from the initial proposal that the website was designed to be separate from the approved Up and Running brand, with no intention of signposting back to Up and Running. So that's the only comment that he makes about the Running Shoes website. And despite Mr. Hager being very experienced in the running shoe business, he doesn't question Mr. McFarlane's rationale for setting up running shoes. Now, as I mentioned, it did come up at the trial, and so I'd ask the court to look at the supplementary bundle, tab 22, 325. So this is in Mr. McFarlane is being cross-examined by my own friend Miss Berridge, and we should perhaps begin at the bottom of 324, where she asks him a question. So it was clear internally you intended to disguise the connection between running shoes and up and running. And then on 325, he says, going towards the bottom after some other exchanges, that this is line 21 on, if a customer bought a pair of shoes from us, albeit a different colourway, but it's the same shoe, and they found they could go on running shoes and bought it much cheaper, then the customer would bring back the product quite rightly for a refund. So the linkage between the second website and up and running, that would cause all sorts of problems for the shop. It's not pleasant having to sit with your customer and say, sorry, we didn't mean to rip you off. It's in a different colourway. Customers see a running shoe as a running shoe. We wanted to keep it not as a secret, but at arm's length. That's, in my view, a better way of describing it. And it's not followed up at that point, but it does come back again at page 349 in the transcript, where he is asked, is why, if you put full, this is line 19 on page 349, if you put full price currencies in stock, I'm not sure that can't be accurate, it must be full price current stock in a store, and then you put discounted old season stock in a website that has the same name, what will happen is customers will either buy the shoe in store after having their gait analysed and all the useful advice. Then they will spot they could have had a similar shoe with just a different colour on the website, and they will go back to the store and say, I want a refund. That is one of the reasons you say you need to keep these businesses separate. So this is a question. His thesis is being put to him. And he answers at the very bottom of 349, yes, I've been doing this for 30 years, not always on the shop floor. And runners know their shoe. They know what they want. And then he explains that to a runner, it doesn't make any difference, but the store still has to carry all the overheads, the staff, the rent, the rates, and all that sort of thing. So we have to maximise the margin to cover these overheads. The internet doesn't carry anywhere near the same amount of overheads pro rata the amount of sales it makes. And then further down the page, this page 350, he says an important factor was that we were in a COVID year, and he's asked to elaborate on this, and says from line 13, in COVID we were locked down shockingly. It was a shock to the system. Nothing could go out of the stores at all, and stocks were accumulating between April and June, and they soon came out of date. So there was a great glut of last year's shoes, and explains that there was a risk of being double stocked, so there had to be a solution. And that's the solution I adopted. So he explains there in evidence about it. And then it's put to him at the bottom of 350. There are some screenshots showing discounted shoes on the up and running website. And it's put to him that, well, he was able to discount on the up and running website. And Mr. Mr. McFarlane explains, this is line 17 onwards on page 351, that those screenshots are misleading because we did not have that massive inventory in previous years that we were facing in 2020 because of COVID. Of course, we have to dispose of these shoes somewhere. And he explains that when you come to the end of a season, you have a run of shoes, and most of the sales will be in commonly required sizes, and you get left, he gives an example, with size 6s. When you go on the website and you click on people's internet, you will always notice that you can rarely buy a size 9 because all the manufacturers have sold out, and that's why they get reduced. So he's explaining that, yes, there are discounted shoes on even the up and running website, but there are rather limited range that would be available. So the discounting is is much more limited in scope.
What does this go to?
Well, it goes to the seemingly contested question of Mr. McFarlane's commercial imperative to set up the Running Shoes website on the basis that he did.
There's nothing in the judgment to suggest that that's wrong.
No, there's nothing
Or
in the
contested.
judgment to suggest that that's wrong.
No.
The judgment it cannot deal with every iota of evidence.
No. But it's implicit in 203 that he needed to sell the stock on the unbranded website if he was going to get rid of them at a reasonable price. I suppose.
I would agree with that. Indeed.
Are you able to tell us what was the size of the stock, the post-COVID stock, as a proportion of the total number of shoes in the product market? Do we have any indication of that? Are we talking about 500, 1,000, 10,000 pairs of shoes or more?
Are you talking about the bulge in stock that Mr.
The COVID bulge, if you like.
Yes.
Do we have any indication of scale?
Well, that's a question of evidence, but Mr. McFarlane can probably...
A million?
A million shoes or £1 million?
Million pounds.
£1 million.
Right, I'm now going to try and work out how many that is.
So, yes, £1 million worth, and he had £1 million worth coming in of new season stock, so cash flow reasons required that he deal with that. So there's the evidence, there's the witness statements. Mr. Hagger doesn't answer the point in his second witness
Not just as Snowden, finger in the air, says it's about 10,000 pairs of shoes, but maybe a bit more than that, 100 quid a shoe.
And then there's also the point which is mentioned in Up and Running Skeleton, paragraph 34, this is Core Bundle 6, page 82-83. Why then did Deckers use clearance websites? If you could discount anyway on your branded website, why did Deckers have resort to these anonymous websites, as your lordship dubbed them yesterday? And then there's also the second corroborating fact about the absolute necessity of this, which is that Mr. and Mrs. McFarlane invested money at a time when money was short in setting up the second website. I don't need to take you to that, but it's in Mr. McFarlane's witness statement, tab 19 of the supplementary bundle. And so why spend money on setting up a website when, as he put it, the circumstances were such that Up and Running was on a road to bankruptcy? The answer can only be because it's the only way of staving off Up and Running's insolvency. And in considering how the judgment dealt with these issues, it's also important to remember that before the cat, the objection to characterization of the facts as an objection, as a restriction by object, was based on signposting and only on signposting. Every argument from Deckers ended up with signposting.
But you won that one on the facts.
Yes, but it's relevant to the context of looking at what the tribunal had to deal with and what was the case put to the tribunal at first instance. Because our concern is that we now have a rather different case. As I say, everything was based on signposting, and therefore that's what the tribunal had to deal with. You can see it even in all the way through to Decker's written closings. I don't need to take you there, but it's in the supplementary bundle, tab 25. It's the last item in the supplementary bundle, page 446, where again they are still using signposting, despite the total collapse of signposting at the trial, which you'll find recorded in the judgment, paragraph 134, subparagraph 9, and yes, of the many the many sub-paragraphs of paragraph 134. That's on page 190, where Mr. Hagger is questioned by Mr. Tidswell about the logic behind signposting. And as the judgment records at subparagraph 9 there, on page 190, Mr. Hagger was unable to give any sensible explanation. He's first of all asked about why customers would be worried about this. And he accepts that.
I mean, the paragraph that's in the agreed statement of facts, 134.15, I think gives you what you want on this, doesn't it?
Yes, I think what I'm just directing your lordship to, subparagraph 9 of 134 is a longer version of that. But in short, no explanation was given as to why, either from a customer perspective or from a brand perspective, there would be a problem. And yet somewhere on the short journey from Salisbury Square to here, signposting has got lost, and so we submit that there's just nothing left that the defendants can rely on here on appeal. All we're left with is abstractions about coherence and integrity to prevent retailers from setting up clearance channels. So, to the extent the court thinks it's necessary to address these specific complaints made that were actually raised against Deckers and how the CAT assessed them against the requirements of carte blanche care, I think, like others, we need to begin with the online sales policy. And the online sales policy, as your lordships know, is in two documents, clause 15 of the terms and conditions, and in an email of 2019.
July email. The July email.
Yes, the July email. Clause 15 is part of the terms and conditions, which are on the back of every invoice, I think, and they're in the supplementary bundle, but for the sake of your eyesight, I would suggest you look at the judgment, core bundle 10, paragraph 134, subparagraph 10. Sorry, I think that's a wrong reference there. But, oh yes, no, it is. I'm grateful. Sorry, I was in the wrong paragraph.
What do you get out of the terms and conditions, which is not the conclusion of the tribunal in 135 and 136? Doesn't that give you everything you need for the purpose of the argument?
Yes, I mean, on the terms, I think the only further comment that might be necessary, I would gratefully adopt paragraphs 134, paragraph 135, 136. The only point I'd make is that if you look at the email, which, if I get my reference right this time, I think is in the judgment.
I mean, in fact, you can go further. You can rely on 135 right the way through to 138, which is fairly condemnatory of the breadth and scope of clause 15 and rejects the justification based upon signposting.
Yes, I'd simply observe that in the July email, although the second part of the first paragraph says that if you want to have another website, let us know. The explanation given is we need to have a complete list of websites. That's perfectly consistent with a selective distribution system. It's inherent to a selective distribution system that only authorised retailers can sell. And so, obviously, if Deckers saw Hoka shoes being sold somewhere on a website they didn't recognise, well, they would want to know, is that a website of an authorised retailer or not? But that's all that's necessary for the purpose of running the selective distribution system. There's nothing to suggest there that the discretion would be exercised to prevent clearance websites. the
Where did this ultimately lead to? Again, given that the tribunal more or less made findings which support everything you're now trying to say, where does it take you?
because just going back to what I'm simply emphasising what was before the tribunal, and all they had was the refusal of second websites for reasons of brand strategy. It was literally a one-liner. That was it. Brand strategy, which was then later elaborated on by signposting. Brand strategy was said to lead to signposting. So that, and there's also the fact that the refusal of the running shoes website has a horizontal element, which is noted by the judgment, and this is also in paragraph 134, that this prevented up and running from making use of clearance websites. I'm sorry, it's paragraph 124, subparagraph 12 is where this point is noted. Yes, it's on page 180. At the end of subparagraph 12, the tribunal says it should be noted in this context that Decker's competed directly with the retailers in the main channel through their direct-to-consumer online channel. So there's an element of economic context which is certainly relevant, we submit, and the tribunal took that into account. But I should perhaps just comment on some exchanges that took place yesterday.
Just before you do,
yes.
And given we're at 1 o'clock, but while we're on the statement of agreed facts,
Yes.
I'm slightly mystified as to why it stops where it stops. I mean, Lord Justice Zacaroli has already pointed out 203, which contains a finding of fact, but there are some fairly significant findings of fact, or what are at least presented as findings of fact, I think, or summaries of findings of fact, between 179 and 181. Which contain, we therefore, in summary, we therefore conclude that.
Yes.
And they make findings as to the purposes of, so the objective aimed clause 15 together with the 29 email, and so as to inhibit the discounting of residual stock, blah, 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 blah. And also in 209, which is something that I discussed with this committee yesterday, where 209 says we've also found in our key factual findings that Decker's intended to prevent up and running selling hooker products at the significant discounts that the running shoes website applied. I mean, what are those? Those are factual findings. I mean, can somebody just certainly tell me whether those are contested, and if so, on what basis, and if not, then I take it they're not challenged or agreed.
Yeah. Well, they're not contested from our side.
Yeah. And while we're on with it, sorry, if you may want to come in on to now or 2 o'clock, so they're happy. But while we're on with it, I noticed, as in many of these types of cases, that in the agreed factual findings, there are still things said in red as being that they are confidential information. 2 important things that were said to be confidential are in the last 2 entries, 1581 and 1582, which were to do with the shares of the wholesale market purchasing of shoes. And yet, Ms. Demetriou stood up and just blasted us with those figures straight away.
No, they've accepted those are no longer. They're waiving. Everyone's waiving confidentiality.
Right. Okay, I missed that. So
that's right. I dealt with it administratively.
Okay.
Yes.
Right.
I mean,
Because sorry. In which case, fine. No, it's been dealt with, and I'd missed it being dealt with.
Yes.
But I reiterate, but I do go back to 179 to 181 and 209 in addition to the other to 203
Yes.
that's been mentioned. So I'm not sure that the statement of agreed facts goes quite as far as perhaps it should.
But perhaps not. But perhaps on 180, 180 is concerned with whether there was an agreement, and that's not contested on appeal. So we're dealing with an agreement. The question is whether it's a restriction by object. So perhaps that's an explanation why 180 need not be something that troubles anybody. For the rest, yes, of course, for up and running, it endorses those other findings.
Is that a convenient moment?
I think so.
If I pass to you?
All rise, evening.